Well, thank you so much. I'm so excited to be here with all of you. My name is Michelle Pardo, and I'm a partner in the Washington, D.C. office of the global law firm of Norton Rose Fulbright, where I focus on animal law, which can be quite the cocktail party conversation, but who our clients are essentially any business or entity whose livelihood deals with animals. It started off in the realm of representing exhibitors, zoos, aquariums, circuses, marine mammal parks, and then very quickly folks in the agriculture community realized that some of the decisions and some of the victories that we were getting and some of the skills we were honing and litigating against animal activists were very transferable to this side of things. And I wanted to give you a little bit of an overview of some things that we've done on that front and some other litigation that is of real threat to folks who do what you do. I'm going to be focusing on the federal and state court litigation, although it is important to remember that what we do also ties in very much so with what happens on the regulatory front, the legislative front, and of course the public relations front. I started working a long time ago on a very famous case that some of you might have heard about. We represented the Ringling Brothers in Barnum and Bailey Circus when the animal activists decided to use the Endangered Species Act to challenge how they cared for, managed, and raised their Asian elephants, which of course are covered by that act. Now you might be sitting here thinking, well, that's great, but I don't have any endangered species at my farm or in my business. But the reason why this case was so groundbreaking was because it was a way that the activists in a very sort of issue of first impression were creatively trying to get a very big animal exhibitor into the courthouse. Most of the time these activists have spent a lot of years in the legislative front, as you all know, at the federal and state level, but it's harder for them to get into court. There is no private cause of action under the Animal Welfare Act, as much as activists would like that, and so they had to find ways to get into court in different ways, and they did so in this case. Once upon a time, there was an ex-employee of the circus named Tom Ryder who was a barn man and cared for elephants and kind of swept up after them. The activist groups, the ASPCA, the Fund for Animals, which later merged with HSUS, Animal Welfare Institute, and the Animal Protection Institute that later became Born Free USA, all recruited him to be a plaintiff, and they sort of piggybacked on him to get themselves into court under the citizen suit provision. That case started in 2003 and went on. It took 9 years to get to trial. We represented Feld Entertainment in that case. But what was really interesting about that case is not just that all aspects of animal care were put on trial. It was because during the discovery process, when you have to exchange documents and litigation with the other side, we were able to uncover a scheme among the animal rights groups to basically take money and funnel it through a charity set up by the lawyers that were representing them in this case, and funnel that money back to the plaintiff to pay him to be in the lawsuit. And that was very hard to piece together and very hard to get the court to let us do the kind of discovery that needed to get there. But that was essentially how we uncovered this very unique situation that led to their case falling apart. Not only kept falling apart, but also having determinations by the trial judge saying that the case was frivolous and vexatious and groundless since the beginning. And you may be thinking again, well, that's a very unique, interesting case. Why do I care about that? I think the reason why a lot of people cared about it and paid attention, it was a very bad loss for the animal rights activists. In fact, Ringling Brothers brought a countersuit against them under the racketeering statute, and that basically takes what are already illegal acts, and when they're done through an enterprise, think kind of Tony Soprano mob crime, and comes together to basically enhance the harm that they're doing to a target. And we brought that racketeering case in the same court against all of those entities that I mentioned and their lawyers, and HSUS by this time had acquired Fund for Animals, and they were in it too. And this is a little bit of the features, the payments that were run through and hidden, the lawyers were involved in it, and what's also very interesting is Tim McIntyre picked up on something in the last presentation. Part of our RICO story that we were telling was that they did this so that they could fundraise on the backs of a very prominent lawsuit. So this really is an example of kind of the underbelly, if you will, of what went on in the animal rights litigation world. Here's a favorite exhibit from our case. It was the check signed by Wayne Patelli of the HSUS. HSUS had taken the position that we weren't involved in this. We weren't supporting this plaintiff. We didn't do it. Of course, he wrote a check and signed it, which became an exhibit in the case. But to this day, they weren't very happy with that exhibit, as well as many others. How did these cases ultimately end? They didn't go to trial on the RICO case. They ended in a settlement, a very public settlement, which was absolutely a condition of the circus settling this case. And ASPCA paid, you can see the figure, $9.3 million in cash with no confidentiality. The others, HSUS, Fund for Animals, Born Free, etc., they paid the circus $15.75 million in cash. For the total recovery, as you can see it, over $25 million. Of course, that figure would have represented almost a decade of elephant care, money that was wasted but ultimately gotten back by the client on that case. It also resulted in one of the largest settlement, as far as we knew, that a charity had to pay out for this kind of activity, and it resulted in charity navigator donor warnings when you went on their website against all those entities for the period of 1 year. So as you can imagine, they weren't very happy about that. Now, again, most animal activists litigation does not end so poorly for them. There are a lot of more run-of-the-mill cases, if you will, and some of the ones that I wanted to profile are in the consumer fraud area. But I have to tell you that working on the Ringling Brothers case, working for other very prominent exhibitors, as well as others who do what you do, have really given us a lot of in-the-trenches knowledge about how these folks litigate, and I wanted to let you know a little bit about that. So, for example, the consumer fraud litigation, we've heard these messages all throughout this program over the last 2 days. This is exactly what fuels what you deal with every day in the marketing world. This is what fuels a lot of these lawsuits as well. Some are brought by enterprising plaintiffs' attorneys. A lot of them have an animal rights component, or, as we've found out in some of this litigation, they'll have a named plaintiff, a nice little school teacher from, say, Northern California, where there's a hotbed of this. But then you come to find out that there's an activist group that's propping her up or helping her or advising behind the scenes. So it's something that we always try to delve into, even if it just looks like a small town person bringing a lawsuit against someone. But again, consumers are wanting that demand for information, for transparency, and they want companies to be telling them every single thing that possibly goes into the production of the product that they're buying. So they like to utilize, let me go back. They like to utilize the consumer fraud action. It's an alternative means in some way for them to litigate something that they can't otherwise do. And some of the cases that we've been seeing and that we've been involved in involve trying the animal welfare kind of process that you all use. And they do that through these very nicely worded consumer fraud statutes in certain states that have very liberal laws. And in this case, a consumer would say, I bought your chicken, I bought your beef, I bought whatever the product is because you used some words on your label or in your advertising. Humanely raised, natural, higher standards, certified by this group. And by the way, all of those terms are incompatible with how I know you are raising your animals. And that is the basis for getting into court. These consumer beliefs and expectations kind of center around what they think humane and natural means. And these are some of the challenges that are in actual complaints that we've been dealing with and we've been watching around the country. They make allegations in the complaint that say if you use the word humane or natural, that must mean the following. The animals get access to outdoors and sunlight, they go out to pasture, they graze and forage, they express normal behaviors, they don't have unnecessary drugs, and so on and so forth. And basically what they're saying is what you're doing is completely incompatible with what we know these words to mean. Now you may be thinking, well, I'm complying with all the government regulations on what I have to do and say in order to label my product humane or natural or any of these things. But the consumer statutes go further, and they go further than what your regulatory obligations often are. So then the challenge is to convince a court, no, we should not be following the subjective belief of what this person says natural or humane should be. All right, so some of these statutes, and they vary from state to state. California happens to have some of the broadest, and this is sort of the three that get generally brought all the time. And we've had some cases in California that are brought with all three of these kind of statutes. So what does that look like? Here's like a sample complaint. Meat products are approved by a third-party certifier to be humanely raised. The consumer disagrees with that animal welfare standard, and what you're doing is inherently humane. And what they might then do is insert things that you've seen before. I have some videos of what happens in the industry. How could this be considered to be humane? You do certain practices that I disagree with, that PETA says are horrible. How can this be humane? Sometimes they actually reference what was referred to yesterday as these shockumentaries. And they say, now that I've seen this documentary, I now know the truth, and therefore your labeling and advertising is deceiving the public and is deceiving me. And that is the basis on which they get into court. And in the alternative, sometimes they will say something to the effect of, even if the standards are okay, you didn't do what you were supposed to do before you slapped on this label or you slapped on your certification. And that's kind of how we see these things evolving in the courts. This is a little bit of the, what some of the laws require. If some of you are unfamiliar, injunctive relief means that you get ordered by a court to do something or to not do something. In these cases, a lot of the times they ask for injunctive relief to stop your whole advertising campaign. You are no longer allowed to say this word. You must change all your advertising. You must change how you describe things on social media. That is often what the activist groups want out of this. Sometimes the focus is more on a refund or money. Sometimes it's refunding the difference between what someone would have paid per pound for something that doesn't have those sort of labeling or advertising attached to it. And the Consumer Legal Remedies Act in California is equally dangerous because it also mandates that all the attorney's fees of the plaintiffs' attorneys get paid for. And a lot of these folks, that's why they bring these cases, just to drum up the attorney's fees. It's a little cottage industry. So you might be sitting there thinking, this sounds awful, and what can I do to protect myself against that? Well, what I like to tell people is the start and finish, even for all of the private litigation, is compliance. A lot of times we forget that we can go back to a basic that we know to be the way we run our businesses. We find in litigation a lot is sometimes in standard operating procedures or in other internal procedures, a company will set a standard for itself and then not follow it. So if you are going to be imposing paperwork requirements, standards, training, or a particular protocol that's going to happen when somebody violates an animal welfare standard or care, you better make sure you're doing it. Because when the discovery process comes, if there's ever a lawsuit knocking at your door, if you don't have those documents, that suddenly can become the feature of the lawsuit, even if that's not why you were in court in the first place. So that's one of the first things I would tell people. And these are sort of a list of some of the legal strategies and defenses that we would look to in one of these cases. Sometimes procedurally we're able to maneuver it into federal court, because as you can imagine, state courts in California, particularly Northern California or in the District of Columbia, are not necessarily the jurisdictions where you want to be litigating things. And if you have products that go all around the country or advertising that reaches people in different states, you could very well be held into court in something that you don't consider to be your home state. Sometimes we will challenge the standing. Now, for a consumer that spent money, that's not really a big fight. But for some of these animal rights groups that bring these cases, like Animal Legal Defense Fund, for example, they never bought your product, even though they're trying to complain about it on behalf of the consumers. Because what they're indeed trying to do is saying, well, we're spending our money fighting to get you to end these deceitful practices of how you promote your products. And therefore, we're injured because we have to spend money fighting against you. And that, believe it or not, will often get them into court. But there's certainly some places where you can challenge that. Oftentimes we will examine the standards and practices that they are challenging. A lot of these complaints often have tons of junk science, lots of animal rights rhetoric, lots of junk science and experts that are recycled. Oftentimes they will also quote standards from other countries and saying, well, obviously if they exclude this from their products, then we should too. And so there's a lot of kind of misinformation to dissect in a lot of these kind of things. Oftentimes we also will try to argue to the court that this is an area that is covered by federal law, and therefore this should not be the subject of one of these state law concepts. You all have to do a lot of things to comply with the federal regulatory scheme and labeling. Some of these groups are smart enough to limit their claims to advertising because they want to try to forestall us from making this. But sometimes the federal regulatory scheme will protect you and will trump these kind of claims. And there's also other procedural things that are very important when you have a case like this. A lot of the times they just want to take your documents that they get in litigation and throw them up all over the internet or use them in their flyers or in their handout sheets or what have you. It is not uncommon to go into a case like this where they want every single aspect of animal care, every single record that you make on a daily basis, and it's our job to chop away and limit the gratuitous giving of every record that you have in a lawsuit, and to get it locked down with an agreement to just use in the case. In the Ringling Brothers case, we actually had a situation where the judge at first would not enter a protective order, an agreement to use the documents only in the case, and at one point we found out they had bought billboard space in New England, and they were taking one of the documents and were going to, the billboard company actually alerted them that they were going to splash it up there. So all kinds of tactics and all kinds of interesting things that we have to go through. So I end with a bit of a little constellation of litigation challenges. But first and foremost, we are looking to not have bad judicial decisions. As we like to say, bad facts make bad law. And so it's equally our responsibility to watch and make sure that we don't have bad facts making bad law. And it's also important early on to, if you find yourself in a situation, get qualified counsel. It doesn't have to be a big, expensive counsel. We help small-time farms. We help people that who are individual animal owners. We help public companies. But sometimes it's just consulting to try to tell people, look, be smart. Know how deep the knowledge is of these activists in the litigation world. They're very connected. They're sometimes 10 steps ahead of the folks that they're suing. And I would just, forewarned is forearmed. So I hope that was a bit helpful.